Namaskar, dear students. I am Dr. Vibha Sharma, Associate Professor in Government Law College, Ajmer. As you can see, this is the third and the final video on forms of punishment, which I'll be sharing under the subject of penology. As I had said in my previous video, imprisonment for life and capital punishment demand some details and hence more time. So, I have tried to cover all the important aspects relating to them. I hope that this video will bring about the much needed clarity on these forms of punishment. So, let's begin. Just for the sake of revision, we will just go through these various forms of punishment one by one so that we remember. So, flogging, mutilation, branding, stoning, pillory, banishment, we already have covered in my first video on the forms of punishment. Fines, forfeiture of property, security bond, solitary confinement, and imprisonment, generally speaking, has been covered in the second video of mine on the forms of punishment. So today we will see imprisonment for life. Now, what does it actually mean? And capital punishment, the much debated form of punishment. Okay? Imprisonment for life. So imprisonment for life has been authorized as a form of punishment under Section 53 of the Indian Penal Code 1860 as amended by Act 26 of 1955 with effect from 1st January 1956. In the year 1983, the Supreme Court, in the case of Naib Singh versus State, held that the nature of the punishment of imprisonment for life is rigorous imprisonment only, and a criminal court could, under Section 418 of the Criminal Procedure Code of 1973, by issuing a warrant, direct the execution of sentence of life imprisonment in a prison. Then we find that amongst other amendments, the Criminal Law Amendment Act of 1983 incorporated imprisonment for life of either description, rigorous or simple, in Section 376 of the Indian Penal Code of 1860. Of course, we already are aware that death penalty has also been incorporated in this section, about which we will learn in the next of the slides. Coming to this case, Kartik Biswas versus Union of India, we find that a landmark judgment was delivered by the Supreme Court because it actually clarified the aspect that whether imprisonment for life is to be considered as for 14 years or for 20 years, or does it actually mean for life? Hope you remember that Section 57 of the Indian Penal Code provides that in calculating fractions of term of imprisonment, imprisonment for life shall be reckoned as imprisonment for 20 years. In its 39th report, the Law Commission of India observed that the executive authorities are competent under Section 55 of the Indian Penal Code or under Section 433 Clause B of the Code of Criminal Procedure to commute sentence of imprisonment for life to one of rigorous imprisonment not exceeding a term of 14 years. They also observed that in actual practice, it is seen that the prison authorities are illegally detaining the life convicts for a much longer period than the aforesaid maximum 14 years, holding that the nature of sentence of life imprisonment does not alter by the aforesaid provisions of the Indian Penal Code or the Criminal Procedure Code, and the sentence remains a sentence of life imprisonment and does not convert into a maximum sentence of imprisonment for 14 years by these provisions. And therefore, they said that this dichotomy needs to be resolved by parliamentary intervention through necessary amendments in the existing criminal law. So in this judgment, the Supreme Court made it clear that life imprisonment is not equivalent to imprisonment for 14 years or for 20 years. Elaborating the point, the court ruled that there is no provision either in the IPC or in CRPC whereby life imprisonment could be treated as 14 years or 20 years without there being a formal remission by the appropriate government. The court also ruled that imprisonment for life is to be treated as rigorous imprisonment for life, and that it was unnecessary for the legislature to specifically say that life imprisonment means rigorous imprisonment for life. And it held that a convict who is awarded life sentence would be imprisoned for the rest of his life unless the government passes an order remitting the sentence to facilitate his early release. Then we find that reiterating the decision of Kartik Biswas in Muhammad Munna versus Union of India, the Supreme Court held that in the absence of an order of remission formally passed by the appropriate government, there is no provision in the IPC or CRPC under which a sentence of life imprisonment could be treated as for a term of 14 years or 20 years. And further, a life convict could not claim remission as a matter of right. And then, of course, in 2008, in the case of Swami Shraddhanand alias Murli Manohar Mishra versus State of Karnataka, the Supreme Court made it explicitly clear that a convict punished with life imprisonment means imprisonment till his last breath. Having reviewed the law on award of life imprisonment as a substitute for death, the court in this case convicted Swami Shraddhanand for life and directed that he shall not be released from prison till the rest of his life. Clear? Of all the forms of punishments, capital punishment is perhaps the most debated subject among the modern penologists. A dispassionate analysis of criminological jurisprudence would reveal that capital punishment is justified only in extreme cases in which a high degree of culpability is involved, causing grave danger to society. It is also stated that the punishment should commensurate, among other things, with the gravity of offender's act and societal reaction to it. Now, experience has shown that despite fullest consciousness about the desirability of reformative justice, at times unequivocal stand is unavoidable in extreme cases where offender has been fully aware of the fatal consequences of his gruesome and brutal crime, and there were no mitigating circumstances. In such aggravating situations, though unwantedly, law must take a firm stand and not hesitate even to award the extreme sentence of death to the offender. These situations have found expression in the penal law of India as also of other countries. Now we are aware that capital punishment has got a retributive effect as well as deterrent effect. So starting with the retributive effect, death sentence has been used as an effective weapon of retributive justice for centuries. We all already know that. The justification advanced is that it is lawful to forfeit the life of a person who takes away another's life. Thus, the motive for death penalty may indeed include vengeance, which is a compensatory and reparatory satisfaction for an injured party, group, or society. When regulated and controlled by law, vengeance is also socially useful. Legal vengeance solidifies social solidarity against lawbreakers and probably is the only alternative to the disruptive private revenge of those who feel harmed. Now, looking at the deterrent effect, of course, the fear of being condemned to death is perhaps the greatest deterrent, which keeps an offender away from criminality. Death penalty in case of, say, murder serves as an effective deterrent to remind the murderer about the severity of law towards this heinous crime and helps in reducing the incidence of homicide. Okay. Now, without going into the modes of execution of capital punishment, we would just see as to what retentionists and abolitionists have got to say about capital punishment. Now, retentionists, those people who want capital punishment to be retained as a form of punishment, and abolitionists, those who want it abolished. So, according to retentionists, elimination of murderers by execution is fair retribution and saves potential future victims. Secondly, punishments must match the gravity of offense and worst crimes should be severely punished. Thirdly, societies must establish deterrents against crime. Death sentence serves as an effective deterrent. And they also have noted that death is a just punishment and death penalty has been held constitutionally valid to ensure justice for condemned offenders. Okay, so these are the views amongst others of the retentionists. Coming to the views of abolitionists, they say an execution arising out of miscarriage of justice is irreversible. Secondly, capital punishment is lethal vengeance which brutalizes the society that tolerates it. And then, capital punishment does not have deterrent effect. Hired murderers take the risks of criminal justice system, whatever the penalties. Thus, it has no rational purpose. And then, they also say that death penalty is unjust and often discriminatory against poor who cannot defend themselves properly. Okay, I hope these aspects are clear to all of you. Of course, we should be aware about the offences punishable with death sentence under the Indian Penal Code of 1860. So we will just quickly go through them. I've just written the number of the section with their headings. Now, before starting with this, it is significant to note that although these offences are punishable with death, but there being alternative punishment of life imprisonment for each of them, it is not mandatory for the court to award exclusively the sentence of death for these offences. Okay? As section 354 subsection 3 of Criminal Procedure Code provides that in fact where the court is of the opinion that the award of death sentence is the only appropriate punishment, to serve the ends of justice in a particular case, it is required to record special reasons justifying the sentence, stating why the award of alternative punishment, that is imprisonment for life, would be inadequate in that case. Okay. So now section 120B, being a party to a criminal conspiracy to commit a capital offense. 121, waging or attempting to wage war or abetting waging of war against the government of India. 132, abetting a mutiny in the armed forces if a mutiny occurs as a result. 194, giving or fabricating false evidence with intent to procure a conviction of a capital offense if innocent person be thereby convicted and executed. 195A, threatening any person to give false evidence. 302, murder. 305, abetting the suicide of a minor or insane person or delirious person or any person in state of intoxication. 307, attempts by life convict. Now, an accused for attempt to murder if hurt is caused. 364A, kidnapping, in the course of which the victim was held for ransom or other coercive purposes. Then, by Criminal Law Amendment Act of 2013, Section 376A, rape, if the perpetrator inflicts injuries that result in the victim's death or incapacitation in a persistent vegetative state or is a repeat offender. 376E, certain repeat offender in the context of rape. Now, this was also added by this Amendment Act of 2013. Section 376AB of Indian Penal Code by Criminal Law Amendment Act of 2018, which deals with Section 42 of Protection of Children from Sexual Offences Act of 2012, also rape and gang rape of a girl under 12 years of age. Section 396, dacoity with murder. In cases where a group of 5 or more individuals commit dacoity and one of them commits murder in so committing dacoity, all members of the group are liable for the death penalty. Okay. So here we will just go through these 3 acts and the respective sections where the offense is punishable with death sentence. Okay. Section 31A of the Narcotic Drugs and Psychotropic Substances Act of 1985, drug trafficking in cases of repeat offences. Part 2, Section 4 of the Commission of Sati Prevention Act of 1987, aiding or abetting an act of sati. Section 3, Subsection 2 of Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act of 1989, case where an innocent member of a scheduled caste or a scheduled tribe is convicted and is executed in consequence of a false and fabricated evidence given by the concerned accused. Okay. Now coming to capital punishment in India. In the previous videos, we already know that Vad Dand was, of course, very much there in place. So the ancient law of crimes in India provided death sentence for quite a number of offences. Now it at times meant amputation by bits. Okay. And it was generally observed that if the offenders were leniently let off, crimes are bound to multiply. So this is how the state of affairs actually continued. However, in the early decades of 19th century, we find that the penologists in India actually reacted to capital punishment differently. Some of them supported the retention of the sentence, while others have advocated its abolition on humanitarian grounds. Now, the retentionists support capital punishment on the ground that it has a great deterrent value and commands obedience for law in general public. Those who support capital punishment feel that death of the killer is a requirement of justice. They believe that death of victim must be balanced by the death of the guilty party. Otherwise, the victim will not be avenged and the anguish and passions aroused by the crime in society will not be allayed. However, the abolitionists argue that enormous increase in homicide crime rate reflects upon the futility of death sentence. Another argument generally put forth by abolitionists is that hardened criminals commit most cold-blooded murders in a masterly manner. They proceed with their criminal activity in such a way that even if they are caught, they are sure to escape punishment due to one or the other procedural flaw in the existing criminal law. Sounds true? Anyway, now moving forward to the Law Commission's reports, that is the 42nd and the 48th report, which was submitted to the Lok Sabha in 1971. In response to the resolution moved in Parliament in 1962 on abolition of capital punishment, Government of India referred the question to the Law Commission. So Commission decided to take up the subject separately for the revision of the general criminal law in view of its importance, and the report, which was presented to the Lok Sabha on November 18, 1971 and of course June 1971, it inter alia observed that even after all the arguments in support of abolition of capital punishment are taken into account, there does not remain a residuum of cases where it is absolutely impossible to enlist any sympathy on the side of the criminal. The Commission further expressed a view that retribution involved in capital punishment does not connote the primitive concept of eye for an eye, but it is an expression of public indignation at a shocking crime, which can better be described as reprobation. Therefore, the Commission did not recommend any material change in the offences which are punishable with death under the Indian Penal Code. However, as regards the question of exempting certain categories of persons from death sentence, it suggested that children below 18 years of age at the time of commission of the crime should not be sentenced to death. It is not necessary to exempt women generally from the death penalty. They also suggested that it is unnecessary to insert a statutory provision relating to diminished responsibility in the statute book. And they said an attempt to commit suicide should cease to be an offense in India. Okay. So the Law Commission strongly felt that capital punishment acts as an effective deterrent, which is the most important object, and even if all objects were to be kept aside, this object would by itself furnish a rational basis for its retention. Okay. Now, moving on to the constitutionality aspect of capital punishment. Coming to the constitutional validity of capital punishment, we will just go through some of the very important judgments of the Supreme Court of India on the subject. In Jagmohan Singh versus State of UP, decided in 1973, the constitutional validity of capital punishment was challenged on the ground that right to live was basic to the freedoms guaranteed under Article 19 of the Constitution. The Supreme Court rejected the contention and held that capital punishment cannot be regarded as unreasonable per se or not in the public interest, and hence could not be said to be violative of Article 19 of the Constitution. Then, the question of constitutionality of capital punishment per se and its application as an alternative punishment under Section 302 came up once again before the Supreme Court in Singh versus State of Punjab. In this particular case, the court actually categorically stated that the provision of death sentence as an alternative punishment for murder in Section 302 is not unreasonable and it is in the public interest. They held that Section 302 violates neither the letter nor the ethos of Article 19 or 21 of the Constitution. And therefore, they held that it is not possible to hold that the provision of death penalty as an alternative punishment for murder is not reasonable and not in the public interest. Now, it is to be noted that this is the case where rarest of rare term was used. Okay, so those of you who are interested can definitely read Muhammad Chaman versus State, NCT, Delhi, judgment of the Supreme Court in which rarest of rare case was explained. Now again, in Shashi Nair versus Union of India, a futile attempt was made while denying the reconsideration of its judgment given in Singh. The Supreme Court again upheld the constitutionality of capital punishment in 1992. Okay. Now coming to the last and the final part of today's video. This case, as you might be aware, is prescribed in your syllabuses as well. So Mithu Singh versus State of Punjab, in which the judgment was delivered by the Supreme Court in 1983, the legality and constitutionality of Section 303 of the Indian Penal Code was challenged. Now, Section 303 provides that whoever being under the sentence of imprisonment for life commits murder shall be punished with death. The court, of course, declared Section 303 as unconstitutional and it held that Section 303 actually violates Articles 14 and 21 of the Constitution. Apart from other things, the court observed that the legislatures chose language which far exceeded its intention. And what was the intention? To discourage assaults by life convicts on the prison staff. And the court also observed that the section assumes that life convicts are a dangerous breed of humanity as a class, but this is not supported by any scientific data. And therefore, they actually declared Section 303 as violative of Articles 14 and 21 of the Constitution. Okay, so yes, I know, and I've been realizing while recording the video also that this video is going to be longer than the usual ones. I hope you understand that it couldn't have been helped. Okay, I really hope that I have been able to cover most of the important aspects on these two, imprisonment for life and capital punishment as such. And certain clarifications have been brought about in this video. I believe that now it is very convenient for you to refer to this video and understand as to what are the different nuances of these forms of punishment. Well, all the very best to all of you for your examinations, for your preparations. Please, please, please take very, very good care of yourselves. All the best. God bless you all. Thank you so much.